Good day, good afternoon, good morning, everyone. This is Jeff Ernst, Vice President of Sales and Marketing with Orange Tree Employment Screening. Thank you very much for joining our webinar today on Learn About the Families First Coronavirus Response Act and other legal exposures for your business. We are excited to have Scott Paylor, partner and attorney with DeWitt, with us today to take us through this particular topic. And before we do that, we'll just have a brief update on Orange Tree. There's a couple of things that we'd like to share with you. I think our clients, prospects would be interested to know. So for those of you who haven't had the chance yet to work with Orange Tree or speak with us, we're in business because every company deserves a background screening program designed fully for their best interest. What we believe is different about Orange Tree in the marketplace is that we offer a no compromise set of screening solutions. We have a full service capabilities for your background screening, drug testing, health needs, including international services, and underpinning that, different aspects of the delivery. You would expect to have technology that you need, compliance that you expect, and customer care that you deserve. And Orange Tree, we believe, is positioned to offer excellence in each of those three areas. Really a point that we want to talk to you about and share with you today, given the market conditions. We're all aware of what's going on with the coronavirus and the different implications nationwide, worldwide relative to that. And as an organization for our clients, as a vendor, as a partner of theirs, as well as those of you who may be considering a change in your background screen provider, we think it's important for you to know that because we work with clients that are part of the critical infrastructure, Orange Tree employers are workers essential to critical infrastructure during the COVID-19 response. So we're here and we're going to be here. Furthermore, we are operating at full capacity. We have passed an internal test of all of our employees working remote. This actually was part and parcel to our business continuity plan, a variety of other initiatives that we have here to always be able to deliver on that capability. Being in the upper Midwest, there are a variety of situations, snow related typically, or ice, where it could be difficult for our employees to get to work. So we've always had this capability, and here recently, last week, we passed that. And as we continue to move forward, our employees are working where they feel most comfortable, whether that's here in the office today or at their remote office. They are welcome to work where they feel comfortable. And again, we are operating at full capacity. As I indicated, relative to our business continuity plan, we are SOC 2 Type 2 certified at a little bit higher level. It's a stringent certification that's earned. It's an IT standard, and we are certified for security, confidentiality, and maybe even more importantly for this given situation, availability of our systems for our clients. We are PBSA accredited, have been for almost 10 years. And one thing that's available for all of you is a website with court closures. We know it's on your mind, what is going on. There's not only private sector entities impacted, but there are also public sector entities, courts, et cetera, that are going through a variety of changes in their availability. We are updating daily the list of court closures, and that link on the page here is available for your purview. And if you need any help or any additional information in that regard, let us know. And then finally, speaking of closed counties, that can present a challenge potentially in our normal course of business, executing against your business policy, the searches that you expect us to execute on your behalf. We do have alternative strategies, methods to be able to provide you the information that you need. And we can talk to you more about that in your specific situation. And we can do additional things in future when those courts reopen again. So just be aware of, we understand what's going on, we understand the impact, and we're working with our clients. We work with anyone who would like to reach out to us to understand more about how we can help you at this time. One thing that we want to share with you also is a recent announcement, their addition to the Orange Tree service portfolio. It's been around for a while. We've recently named it Constant Connect, and it's our ability to provide a number of services for our clients on a regular basis or a near real-time basis. Depends on the service, but this has been an enhancement to our capability to provide information to our clients on the status of their employee population, It's been very popular. It's been very successful. And so we want to make sure everyone is aware of that. A little bit more detail within the Constant Connect portfolio is that not only is it let me pause. It's a variety of services. You can do criminal searches, global watch basis. There's a variety of services within this portfolio. Our clients are taking a pick and choose, as you would expect, approach to this. They're in specific industries, have specific business policies and interests, and as such, we are crafting and developing customized solutions to what they want and need on a regular basis. And so to the extent this is of interest to you, we'd love to talk to you about it. We have many clients signed up, and it continues to be a popular item for us because employers are truly trying to assess, reduce their risk by having more and continual information about their employee population. So as we considered this call, we considered what we're going through, that we recognize that the market condition may have created a budgetary challenge for you. We also expect that the market will change again and that companies will start to rehire many of those individuals that were let go. In this case, many companies will want to run a quick check on these employees because of their obligations to ensure that they've taken reasonable measures to ensure a safe workplace. No one planned for this surprise or interruption to their business. We've created several return to work packages because we believe they could be relevant to many businesses and they may possibly ease your burden at this time. Each business situation is going to be a bit different. There's a difference between a furloughed employee and one that's been laid off. Your industry and business policy also drive the services that will be of interest to you. Finally, we have clients with less than 200 employees and more than 20,000, so the needs of everyone is likely to be a bit different. Our objective in creating these packages is to let you know we're thinking of you. We know that many of you have already had to make difficult decisions regarding the employment of your personnel. We know others of you may have to make similar decisions in the upcoming days, upcoming weeks. So Orange Tree wants to help businesses manage through this situation the best that they can in the best way that we know how. We provide fast, easy, and accurate background screening. If this approach is interesting to you, please reach out to our client success team, your client success partner. If you're a client, reach out to me if you'd like to learn more about what it might be like to do business with Orange Tree. You can see the packages, you can see the pricing that's listed on the screen, and we just want to be here to help you with what you need at this particular time. So with that, I'd like to provide an introduction to Scott Paler. Scott is a partner and attorney at DeWitt. He serves as chair of the firm's background screening practice. He's a past chair of the firm's employment practice group and is an active member of the firm's litigation team and litigation group. So I am going to turn over control of the presentation to Scott and let him take us through the core of today's presentation. Thank you, Scott.
Thanks, Jeff. Appreciate it. And thanks everyone for taking some time out of your day. Obviously, we are in an unprecedented situation. It really feels like a bad movie. I think the first thing I'd like to say to everyone is I hope you personally are doing okay and your families are as well, because none of us have ever seen anything like this before. We certainly know that coronavirus is top of mind for all of our employer clients right now, and really all the businesses around the country. And so, although Orange Tree and DeWitt had originally planned for today's webinar to focus exclusively on background screening compliance risks and best practices, we both agreed that the best plan in light of today's changed environment is to focus initially on coronavirus-related issues, and then transition to a little bit of background screening compliance stuff after that, and then take your questions on either of those topics. Big picture before we begin, there's never been a more important time to have a plan. And I would also add that although reasonable minds can always disagree on when is the right time to reach out to legal counsel, I can I can suggest to you that this is one of those times where it's more important to have your legal counsel on speed dial than usual. The situation remains entirely fluid, so I can tell you, even before I got on to this webinar call today, I was exchanging emails with my colleagues about the stimulus bill that was passed yesterday and what changes the stimulus bill may present to the FFCRA that we're going to be talking about today. So things are going to continue to change on the ground, and with those changes on the ground, it's going to be important for businesses to remain nimble as well. So please use today as a starting point, hopefully a good primer, but only as a starting point. There'll be lots to sort through. So let's start out with coronavirus related issues. All of you have, I imagine by now, heard that the federal government has introduced a new law that provides certain paid sick leave benefits and certain expanded FMLA benefits to employees of businesses that are below a certain size. The first thing I want to bring to everyone's attention is the effective date, because even something as simple as the effective date has been debated since this legislation was passed. The Department of Labor in their FAQs came out just, I think, yesterday or the day before, and made clear for the first time that the effective date is going to be April 1st, so coming up here soon. All of the different rights and responsibilities that I'm going to go through in these next handful of slides become applicable beginning April 1st. I know there were a lot of questions about the possibility of retroactive application. To this point, we don't believe any of the rights and responsibilities that I'm going to talk about next are retroactive. And the Department of Labor has emphasized in their FAQs that this law is not retroactive. So everything I'm about to go through with you becomes applicable only starting April 1st. So the first thing to know is that this law does not apply to very large companies. It only applies to employers of 500 employees or less. Now, I know that some of you, based on the questions that you submitted in advance of this webinar, are wondering how you count employees. And that can be even a challenging issue right out of the gate. Here's what I would tell you as a starting point. In general, 500 employees is evaluated by looking only at United States employees. So the DOL has said in its guidance that it is not appropriate to look at employees in various other countries around the world, though US territories do count towards the 500 number. Another thing to know is that pretty much anyone that's been on or that's on the payroll is included within that 500 number. So that includes both active employees and employees on leave. It also includes, temporary employees for which you're a joint employer with a staffing company. Okay. A number of people have asked whether 500 employees does or does not include related or affiliated businesses. That is a much more complicated question and one that is important to sort out with legal counsel. I would say as a general rule, corporations or business entities are treated on their own. So it starts as a proposition about whether the particular company at issue that is being asked to provide paid sick leave or additional FMLA leave, whether that company has 500 or more employees. But there can be situations in which related employers or affiliated organizations can have their employees also count. And usually that comes down to how integrated or associated those two separate businesses are. It's too difficult in the context of today's brief presentation to go through all the ins and outs of that integrated employer theory, but it is something to talk about with legal counsel if you are close. The second thing to know out of the gate, so let's assume that you have 500 or less employees, and now we are at April 1st. The second thing to know out of the gate is that this law really only becomes relevant for employees that cannot telework. So there's a big misconception out there right now that's floating around the media that just about anyone can claim paid sick leave or expanded FMLA benefits. That is 100% not true. For those of you that operate businesses where employees can easily work remotely, in the majority of circumstances, those employees will not be eligible for the paid sick leave or expanded FMLA benefits. Now, does it become more complicated than that from time to time? It does. So imagine that employees can telework, but they are, let's say they're a single parent and they're responsible for caring for their children at home, and they take the position that they are not able to effectively telework because of their other responsibilities around the house in this very difficult environment. That's the type of issue that if an employer takes a harder line position is going to potentially be litigated, okay? So many employers that hear that sort of complaint or receive that sort of position from employees are going to err on the side of caution and allow employees to exercise PTO or expanded FMLA rights if it's close. The third thing to know out of the gate is that employers are eligible for tax credits equal on a one-to-one basis to the sick leave payments and expanded FMLA payments that we're going to talk about today. So I've had so many employers come to us and say, how in the world can we afford this, right? There's no way we can afford this. And one thing to keep in mind is that tax credits are available. Now, whenever I say that, there's always the follow-up question, which is, wait a second, I can't wait for a year, okay? Well, most employers, in my experience, are paying payroll taxes every month, or they're paying them every quarter. What the Department of Labor and the IRS have now said is that employers can actually withhold owed payroll taxes in connection with these paid sick leave and expanded FMLA benefits. So if an employer, let's say, makes $5,000 in sick leave payments in a particular month, then they likely can subtract that $5,000 from the owed payroll taxes in the upcoming period. Okay. The other thing that the DOL and IRS have said is that if an employer is owed more in these tax credits than they have to pay in a given period of time, then the employer can make a request for a refund. And the IRS at this point is saying that they are prepared to process those refund requests within 2 weeks' time. Is it going to play out that way? I certainly hope so. I don't know, but that is what they're telling at this point. So those are three really important things to understand out of the gate. Where we're going to go now from here are some of the details related to the PTO provision and then separately the expanded FMLA provision. And that's an important thing to keep in mind before we dive in, is that these are separate. There is a PTO or sick leave provision that we're going to talk about first, and then there's an expanded FMLA provision that we're going to talk about second. They each have their own criteria. They each have their own amount of payments that are owed by the employer. They are not the same, okay? And so we're going to take them each in turn. So the first one is the sick leave or PTO provision. And under the law, employees are eligible for up to 80 hours of paid PTO at capped amounts. And we're going to talk about those capped amounts shortly. The reason I say up to 80 hours is because for employees that are part-time, that work less than 80 hours in a typical 2-week period, they're only eligible for a proportional amount of PTO. So if they're only working, let's say, a 60% schedule, then they're going to be eligible for 60% of the 80 hours. The PTO provision has certain qualifying criteria, which you see on your screen at the bottom right now. There are 6 different bases that employees can rely on to claim that they are qualified for PTO. And again, this is in situations where they cannot telework, okay? Most of us now, I'm here in Wisconsin, most of us now are becoming subject to these stay-at-home orders where we're essentially having to work out of our house. And in those situations, employees can potentially claim these sick leave benefits. And again, I'm talking about situations where they cannot telework, all right? There are other situations where they can as well, and those are situations in which they themselves are sick with COVID-19, or they're seeking medical diagnoses related to COVID-19, or they're caring for others that are in those situations, or they have a child that has a closed school due to COVID-19, which is pretty much everyone at this point, and they are having to take care of a child in those circumstances. We are almost at the point now where just about everyone across the country has employees that fit into one of these categories. So by and large, we are transitioning away from the qualifying criteria, since just about everyone is going to be qualified. And instead, it becomes a question of whether or not they're able to telework or not. So assuming that they can claim PTO benefits, what are the amounts that they're owed? It's important to understand that employees do not get a one-for-one reimbursement for their dollars regardless of their income. So imagine an employee that has an income of $100,000 or $150,000 or $200,000. It doesn't mean that they are going to get a paid PTO exactly equal to what their salary or wages or income would have been for that particular day. It's capped. And so employees' reimbursement is capped at $511 per day if it's their own illness and it's their own reason that they're out, with an overall aggregate cap of $5,110. And then the amount is lower, it's 2/3 of pay, if they are caring for another individual. So their qualifying criteria is that they're caring for another individual in these COVID-19 circumstances. Again, if they're caring for family members, the amount that they're entitled to for reimbursement is capped at $200 per day and $2,000 total. Now, several of you are probably looking at my screen right now and paying attention to that phrase, regular rate of pay. That should sound to you like a lawyer phrase, because it is, okay? Regular rate of pay means that we have to factor in not only, let's say, an hourly employee's base wage, we also have to factor in additional amounts that they may receive during the course of their work. So let's say they're receiving commissions, or let's say that they are receiving payments because they're working extra hours, they're working late night hours and they're getting premium pay, right? If they are receiving additional dollars, then they are eligible for additional reimbursement, though again, subject to these caps. So in the DOL FAQs, which are available publicly, and I strongly recommend that you take a look at them, they talk about this issue of regular rate of pay. And what they say is the way we should determine regular rate of pay is to look back over a 6-month period and figure out the average daily pay over that 6-month period, okay? Now, there are certain things that can be excluded, it can get complicated, but at its most basic level, we're looking back 6 months and we're evaluating the income that they receive on average day by day, and using that to determine that the amount that they're owed under this PTO law. So far, we've talked about the PTO provision, or the sick leave provision, which is 1/2 of this FFCRA new law. The other part of the new law is an expanded FMLA provision. Now, usually, as you know, the FMLA only applies to employers that have at least 50 employees. And so if you are an employer that has less than 50 employees, typically you don't have to worry about FMLA. That is no longer the case when it comes to what we're going to talk about now. So this expanded FMLA law applies to employers that are smaller than 50 employees. It applies to every employer under 500 employees. Now, some of you, and I've seen this in the questions that you raised with Orange Tree going into today's session, some of you may be saying, wait a second, isn't there a provision in the law that says employers smaller than 50 employees may be able to take the position that paying these benefits is going to break the company, and therefore ask for a get out of jail free card? And the answer is, conceptually, that's true. So far, the Department of Labor has not defined the criteria by which employers smaller than 50 employees can claim that exception. The DOL has just said it's forthcoming in hopefully the next few days. What they've also said is that it will be up to those smaller employees to document the reason why they can claim the exception once the DOL lays out the criteria, and that small employers will not be required to submit a request formally to the DOL to ask for that permission slip. They'll just be able to claim it, and then it would be up to individual employees to raise an issue if they believe something is amiss. There are many challenging questions that come up with this expanded FMLA provision. And one of them is, when can individuals claim this expanded FMLA right? What can they claim, and how does it intersect with the usual FMLA stuff? So on the first issue, employees are eligible to claim up to 12 weeks of FMLA if they're caring for kids home from school due to COVID-19. So look at how narrow that is compared to the sick leave provision that we talked about a moment ago. That sick leave provision has 6 different bases for employees to claim that they're qualified. The FMLA provision is limited exclusively to caring for kids that are home from school due to COVID-19. So it's a much narrower qualifying criteria. Second thing I wanted to mention is that at this point, most of the lawyers believe that this sort of FMLA-related leave can be taken on an intermittent basis, meaning that employees don't have to take a lump all at once. They don't have to take, let's say, 12 weeks or 10 weeks at one time. They can take them more sporadically, in 1 day, 3 day, 2 week periods, shorter periods of time. That may become more relevant if kids start going back to school and then again the schools end up closing during the course of the year. We can imagine that happening. Unlike the usual FMLA, which is totally 100% unpaid under federal law, this particular expanded FMLA right comes with the ability for employees to claim a payment, to get reimbursed. And you see on your screen right now what they can get reimbursed for. They can get up to $200 per day and $10,000 in total if they are eligible for these FMLA rights. Now, some of you may be saying, okay, there's the sick leave provision that provides for a certain amount of time, provides for 10 work days off potentially, and then there's the FMLA provision. How do they integrate together? And the answer is that the DOL has said that 12 weeks is the maximum, right? So if an employee takes 2 weeks of the paid sick leave benefit, then they're eligible for 10 weeks of FMLA. And the total amount of money that they could be making in a situation, let's say, where they're caring for kids, they could make $2,000 under the paid sick leave provision, since that's the cap when you're taking care of kids. And then they could make $10,000 under the FMLA provision potentially. So the maximum amount that the DOL says they could claim is $12,000 in that instance where they're off because they're taking care of kids. So far, we've talked about this new paid sick leave law, and we've talked about this new expanded FMLA rights. But obviously, there are a lot of questions that come up related to coronavirus and what companies must do. And I can tell you that we at DeWitt have been having morning till night conversations with clients every day to try to figure out what the best recipe is. It's obviously not the same for each employer. Everyone has different interests. There is different concern about laying off employees. There are different concerns about the ability to bring back employees. Some employers are more concerned about their ability of employees to claim insurance benefits. Some have more salaried exempt employees than others. Others have almost exclusively hourly. And all of those sorts of things factor into the decision about what to do. What you see on your screen right now are examples of things that businesses are considering in this environment. And these are the biggest ones that I would say we're talking about right now. Obviously, it starts with working remotely, right? Because if our businesses can continue to operate, we can continue to service customers. Hopefully, we still have customers. Then working remotely is usually the best thing for everyone. right? Because employees maintain their jobs, the business continues to move forward. As long as we can do that smoothly and efficiently, then that's, often the best first alternative. But that best first alternative is obviously not going to work for everyone. So what you see on the remainder of the slide are the other things that employers are considering. They're considering decreasing hours for staff. So talked to one the other day that has lots of people hourly that are working full-time traditionally, and they're reducing their hours to 32 hours for the time being, with the idea of trying to keep people on as long as possible. I have other employers that are reducing their pay for staff, right? So obviously you're still subject to minimum wage requirements. If individuals are salaried exempt, you're subject to those requirements under state and federal law, so there are minimum levels, but many employers are paying workers above those minimum levels. And so some companies are considering now, for the weeks that are coming up, reducing pay, again with the idea of trying to keep as many people on board as possible. That ideally or theoretically, it's preferable to some companies to keep more people on staff, even if everyone has to sacrifice a little bit with lower take-home pay. Another thing some employers are considering is placing individuals on unpaid administrative leave. And so essentially the message to both hourly workers and salaried workers is, we do not have the work for you, but we are also not terminating your employment right now. And conveying to salaried exempt workers that they are not on a salary exempt status anymore, and they will not be paid because they will not be working. Now, what some of our clients are doing in that instance, though, to try to cushion the blow, is to call their insurance provider and ask for the insurance provider to waive the minimum hours requirements that are typically in place for individuals to become eligible for insurance. So usually it's a 30 or 32 hour minimum. I have many clients that are talking to their insurance company and succeeding in convincing the insurance company to waive that minimum requirement, at least for like a 90-day period. And so the idea is that employees are transitioned to unpaid administrative leave status, but that both the employer and employee will contribute to premiums for those insurance payments going forward in the same way that they always would, and that would enable employees to stay on insurance, which is obviously a top of mind concern for many employees. Another thing that employers are considering is transitioning salaried workers or salaried exempt workers or non-exempt workers to hourly status, right? And one of the reasons to consider that is, there may not be enough work to justify XYZ salary at this point. But what if you could go to the employee and you say, all right, this week we're going to have you work 10 hours, and this week we're going to have you work 20 hours, and this week 15, right? You have more flexibility to go to them and say, we want you to work this period of time, and we're going to give you $15 an hour, $25 an hour, $35 an hour, whatever it may be, right? You have that option because companies always have the option to treat workers as hourly if they want to. Now that means that in general they won't be eligible for exempt status, but we're only worried about exempt status when people might be operating in overtime, right? And by and large, people these days, except in very narrow industries, are not going to be close to working overtime. That's obviously not the biggest concern right now. The other thing that a lot of employers, unfortunately, are having to consider, and we've had countless conversations like this over the last few days, is the possibility of a layoff, right? And many employers are doing this layoff before this April 1st sick leave and expanded FMLA leave law becomes effective, with the idea of essentially not having to deal with that new law and dealing with tax credits and reimbursements. I would say that many employers are also considering layoffs because their customer orders have fallen off. Like I talked to one yesterday that had a 90% decrease in customer orders almost overnight, and they have no idea when that's going to turn around. So for employers like that, layoffs are absolutely something to consider. Now, normally with layoffs for employers above a certain size that are laying off a significant percentage of their workforce, it becomes necessary to issue what's called a WARN notice. A WARN notice is a notice that is required under federal law and sometimes under state law. that usually announces to employees that they're going to be laid off 60 days into the future. And that 60 days is important because it usually provides a lead time for employees to sort of transition away and look for new job opportunities, et cetera. The other purpose of the notice is to provide local and state authorities with an indication of this new layoff so that local and state authorities can make arrangements if needed. So often, for example, we all see indications on the news that such and such employer is going to lay off, 2,000 employees, right? And usually they know about that in the media because of these warn notices. Now, many employers, not surprisingly, are saying they cannot give employees a 60-day lead time right now. It's just not feasible. Customer orders have decreased too much. And so by and large, employers are basically taking on the risk that comes with not providing that 60-day notice. And there are usually certain exceptions under federal or state law that arguably come into play. So there's a natural disaster exception, as I recall, under federal law. And arguably this pandemic is akin to a natural disaster. Often the state exceptions mirror the federal law, but not always. So what some employers are doing is sort of a compromise effort, is that they are crafting a warn notice that meets the technical requirements of warn or state law, but they are not extending the 60-day lead time. So it's a way of sort of documenting why they're doing what they're doing, trying to meet technical requirements, and it's a way of trying to look like a responsible adult in this situation and not one that's acting haphazardly. What percentage of our employers do I think are doing warn notices right now? I think it's the minority. So it's something to consider, but many employers are deciding at this point that they're just not going to do anything. And the hope is that after all of this shakes out, whether it's weeks or months from now, that there will be some understanding at the government level and at the courthouse level of why people did what they did. But this is obviously a strategic decision to make. So far we have talked exclusively about coronavirus related stuff. I imagine we could spend hours and hours for the rest of the day talking about coronavirus and even just answering the questions that you have. We will leave time at the end for you to answer questions, and I'm also, as I mentioned to Orange Tree, happy to try to stick around and answer some additional questions beyond the 2 o'clock Eastern, 1 o'clock Central hour for people that are still interested. I am going to go through a few background screening compliance related topics now for the next 10 or 15 minutes or so. We're going to breeze through these because of the time we spent on coronavirus. But there are some important things to know, and we want to bring those to your attention today. So one thing to keep in mind is that background screening class actions continue to surge. And there are all different reasons for this. It's the increased familiarity of the plaintiff's bar, it's the highly technical requirements, it's the fact that employers are making those same decisions and using those same procedures over and over again. It's that favorable case law for the plaintiffs continues to grow. It's the size of the settlements we're seeing and the damage structure. There's lots of reasons, but what I would tell you in sum total on this is that background screening class actions are kind of the perfect storm. And we expect them to continue to grow in number and for them to continue to be lucrative for the plaintiff's bar. We're going to talk about two areas in particular today that the plaintiff's bar is focusing on. We're going to talk about what's new in those areas and hopefully how to manage those risks a little bit better. So the first thing relates to written consent paperwork. There is no background screening class action that is increasing in number more readily, more quickly than background screening class actions related to written consent paperwork. And by and large, you might be surprised, it really comes down to one piece of paper. And that one piece of paper is called the disclosure. It's a requirement under the Fair Credit Reporting Act, which is the federal law that governs background screening checks. And what the FCRA says in very limited detail is essentially that an employer must provide a standalone document or a document that consists only of the disclosure to the job applicant or employee that says we are going to obtain a consumer report on you for employment purposes. That's about all it says in there. And so plaintiffs' attorneys have taken the position in the last 3 or 4 years, or it's probably more like 6 or 7 years now, that the disclosure is invalid and the background screening consent process fails if the employer is inserting extraneous information into the disclosure. So if you're throwing in stuff that doesn't have to be there, then that invalidates the consent process and means that you're running a background check without consent. We are seeing these background screening consent cases like crazy, and in particular in 2 jurisdictions, in California and New York. Those are both hotbeds for these. There is a new Ninth Circuit case that came out, I think it was on Monday of this week. So this is as hot off the press as can be. And the Ninth Circuit is ground zero for these background screening consent cases. And it is one of the most, if not the most insightful background screening consent case that I have ever seen. And it provides a lot of help to us in determining what should go into that FCRA disclosure and what should not. So what the Ninth Circuit says is it's okay to say that reports will be obtained by the employer for employment purposes. All right, we got that. But what it also says is that it's okay for employers to include a definition of consumer reports. So that definition comes directly from the Fair Credit Reporting Act. It's okay to identify examples of the types of information that will be included in the background check. For example, you're going to obtain criminal history information and credit information and education and employment verification information. And it's okay, they said, to include the name of the background screening company because that provides surrounding detail that helps the job applicant or employee to understand what's coming. What they said is not okay, that might surprise some employers. They said it's not okay to discuss a job applicant or employee's right to find out more information about the nature and scope of investigative consumer reports. So those are interview-based reports. So if the background screening company is doing substantive reference checks for the employer, there's certain additional information that has to go to the job applicant or employee. Often in the past, that additional information about investigative consumer reports was combined with the information about ordinary consumer reports. And what the Ninth Circuit has said here is, if you start really talking about that in any detail, you're going too far, you're including extraneous information, and the document is invalid. They've also said that although a job applicant or employee has the right under federal law to gain access to information that the background screening company has in their files, that it is illegal for the employer to talk about that right in the FCRA disclosure because it's extraneous information. What the Ninth Circuit also said is that it's really important to double check that the disclosure is clear and conspicuous, right? So we want to be using subtitles. We want to be using paperwork formatting. We want to be using bold print and other things to make sure that employees are really seeing it. It's really clear what's going to happen and that it's not hard to follow, that the language is clear and easy to read. What you see on your screen now are examples of what can go wrong when companies don't handle background screening consent processes in the most favorable way. And I constantly get questions from employers and even from background screening companies saying, oh, come on, this is also technical. What does it matter if there's a few extra words thrown in, if you address additional topics, right? The employee understands that they're consenting to the check, and that's all that really matters. What you see on your screen right now are examples of why that line of reasoning is not quite accurate, okay? People are paying out enormous settlements, 7-figure, 8-figure settlements related to highly technical background screening consent allegations. This is why it deserves front burner attention in a way that 10 years ago it simply did not. So what are some best practices related to consent paperwork? The key thing is actually to keep it short. One of the ways that's sort of counterintuitive that employers get into trouble is they actually try to put too much stuff into the disclosure that really is designed to be helpful to the person. It's designed to be helpful to the job applicant to make sure they understand all the surrounding circumstances and things related to employment, et cetera. It is all of that extra helpful stuff that is actually not helpful at all, okay? And so on your screen right now, you see 7, 8, 9 different examples of things that I see regularly when I review these consent forms where the disclosure has additional stuff in that I wish were not included. And it's everything from state law notices related to background checks, to discussion of investigative consumer reports, releases of liability, at-will employment statements, statements that you better be honest with us during the application process or you're going to be rejected from the employment hiring process. Even talks about a federal notice called a Summary of Your Rights under the Fair Credit Reporting Act. Essentially anything that we think we need to cover that isn't absolutely necessary for the disclosure ought to go on a different document. That's the end-all be-all on this stuff. The other thing I wanted to mention apart from background screening consent relates to adverse action procedures. So hopefully you're all aware of this, that under federal law, and it's also true under certain state laws, that employers have to go through a three-step process if they're thinking about rejecting a candidate or terminating an employee or demoting an employee based on their background screening report. And the first step is they have to provide a copy of the report and a federal notice called a Summary of Your Rights under the Fair Credit Reporting Act to the person and allow them to dispute any inaccuracies in the report, right? So it's essentially a way for the applicant or employee to say, wait a second, there's something wrong with this report before any adverse action is taken. And then the employer has to wait a reasonable period of time to allow people to raise those disputes and do certain other things. And then they have to close the loop by providing a post-adverse action letter. So let's assume that the candidate did not raise the dispute and they are going to be rejected based on their background screening report in part or whole. Then the employer has to send out a post-adverse action letter. And there are very specific sentences that have to go into that post-adverse action letter. It is strictly regulated by federal and some state laws. So how are employers getting into trouble? Well, they're getting into trouble by not following one step or another, right? And you see on your screen examples of companies that have settled cases involving adverse action allegations. And again, similar to the background screening consent lawsuits, these adverse action related lawsuits are often resulting in eye-popping settlements, right? These are the types of settlements that attract more plaintiffs' attorneys. And I have not just cherry-picked adverse action settlements that are unduly high. This is representative of the numbers that we see. And the biggest reason is because adverse action cases, like consent cases, are typically handled on a class action basis. And when you're talking about large companies that are hiring lots and lots of people, then the class becomes very large. And whenever you have large classes, you have large settlements, right? Because a lot of these settlements are only resolving for $30 or $40 or $50 or $100 per person. But if you multiply $30 or $40 or $100 per person by 10,000 candidates or 5,000 candidates or 50,000 candidates, the numbers become explosive very quickly. So what are some best practice ideas for adverse action letters? It's really the nuts and bolts. It's making sure that both the pre-adverse action letter and the pre-adverse action and the post-adverse action letter are sent. It's not one or the other, it's both. It's making sure that the wording is good, right? So we don't want to say in the pre-adverse action letter that someone's been rejected when they haven't been given the dispute period yet, because that suggests that the dispute period is really a fiction. It's important to make sure that the post-adverse action letter is right, and there are not verbal comments that essentially say that the process is over. So sometimes I'll see employers that go through the three-stage adverse action process, but there's a front-end call with HR or the recruiter with the candidate that said, you're out, right? You're not going to be hired, right? That sort of thing can create problems. And we also see problems related to matrices where there are automatic sending of adverse action letters. Sometimes that can be helpful. It certainly drives efficiencies, but it's really important to try to get that right and to make sure that the process works in a way that accommodates the rights that each candidate has under federal and state law. And then the other thing which we haven't talked about today related to adverse action, there are a number of states and municipalities that now introduce additional requirements above and beyond what the Fair Credit Reporting Act requires, right? And so many times I'm dealing with employers that haven't updated their correspondence for 5 or 10 years. 5 or 10 years ago that may have worked, but in today's environment, if you're dealing with California or Washington State or New York or a number of other jurisdictions, there's additional information that must go to candidates or employees during the adverse action process. And if that information is not conveyed, it's just a black and white violation of that particular jurisdiction's laws, and it can give rise to damages. I know I have absolutely flown through the background screening consent and the adverse action stuff. Normally we would spend a lot more time on it, but we certainly understand that coronavirus is the biggest concern that everyone has right now. I'm going to flip it back to Jeff at this point. I know there are a number of questions that came in before our webinar today, and I imagine some of you may have additional questions that you've conveyed to Jeff during this webinar, and I'm happy to try to answer those questions now.
Scott, thank you very much. I mean, for making a very difficult, complex, probably evolving, spiraling sort of topic approachable. And I appreciate your clarity and attempt to provide the counsel you can here in this call. But we do have a number of questions. I'll just kind of start from the top, where the question submitted: if you hire someone during this time, can you require them to take temperature checks prior to starting? Can you push the start date?
Yeah, so that's a whole nother topic, right? I would say, traditionally in the past, temperature checks were 100% not allowed, right? It was a medical exam under the ADA and it was not permitted. The EEOC, though, has come out in the last week or so and made clear that temperature checks can be administered in this unusual pandemic environment. What I am telling employers, though, is if they're doing temperature checks, they should administer them consistently. Right? So you wouldn't want to identify just one job applicant or candidate and run a temperature check on them, but not run it on other similarly situated applicants or employees, right? So consistency really matters. In terms of pushing out start dates, what I would say is that, to the extent individuals have the coronavirus, or are believed to have coronavirus, I think they really fit in the same category as our current employees, who we're going to say don't come to work under those circumstances, right? So I think yes, in this unusual environment, start dates potentially can be pushed back, but that is definitely a topic to confer with legal counsel about before it's done, because it comes with a number of ramifications, obviously.
Thank you. You may have covered this. I may have been writing down questions. Are employees entitled to workers' compensation benefits because of COVID-19?
Yeah, the answer is they might be, right? So I think if they were able to show that they acquired COVID-19 by virtue of their work, then I absolutely think they could potentially acquire workers' compensation benefits. It may be challenging for employees to demonstrate that causation, so there can be legal arguments on that, but I think it's theoretically possible, yes. The other related question I'm getting from lots of employers right now is, okay, we have a bunch of employees that are working from home, and what if they injure themselves going up the steps at home or whatever it may be? Does workers' comp come into play? And the answer is yes. So as a general rule, and it obviously varies state to state, workers' comp is a state issue, but as a general rule, if employees are injured while doing work at home, then they are covered by workers' comp.
Okay. In thinking about the reimbursement of employers' contribution to the employee health insurance premium, is there any difference when it comes to union and non-union employees? Follow-on question: should companies look to establish hazardous pay for the industries that are considered essential and still operating?
All good questions. I would say on the initial question, the CBA is always the most important thing in the unionized environment, right? So the first question, or the first place to look to any question in the unionized environment, is what does the CBA say? If the CBA does not cogently answer the question, then the next step is likely to reach out to the union and negotiate on the issue, because anything related to employment that bears upon terms and conditions of employment generally has to be negotiated. In terms of the hazardous pay question, I think that's an interesting one. I wouldn't be surprised, I haven't gotten this question yet from any of my employer clients, but I wouldn't be surprised if employers are going to start offering hazardous pay to employees as a way of incentivizing people to come, right? Because there's going to be so many employees that don't want to come out right now. And yes, you know, in some circumstances, employers can use a stick approach and essentially compel them to come in. But we're already seeing some employees quit in that situation. And so, yes, I can imagine some employers offering some sort of premium pay or hazardous pay in this environment in order to incentivize work. But we're obviously going to want to make sure that the messaging is good, because we don't want to make it sound like we're essentially setting up employees for a fall. So I think the communication has to be well thought out, but the possibility does make some sense to me.
Very good. I'll remind everyone on the call that the call is being recorded. We will send out an email with a link to the webinar recording itself. It'll just take a couple of hours for the webinar to be recorded, available for you to listen to again in case you want additional clarification. You weren't able to take the notes that you wanted to while you were listening to Scott. 2, you can obviously share that webinar, this webinar, with somebody else. So feel free to do so. Look for that email a little bit later. There is a handout online that you can download. It has the slides, and we're right about time. I will continue to go through questions. We will go a little bit after 1 o'clock, but I just want to give everyone kind of that heads up that there's other ways to get this information if you have a hard stop here and you need to drop. Another question. One for this organization is the expanded FMLA of 12 weeks. Can it be taken as intermittent leave as long as it's used before December 31st of this year?
Yes, at this point, we believe the expanded FMLA can be taken on an intermittent basis, but I would say from my perspective, it hasn't totally been fleshed out yet, but that's our expectation, yes.
Just a follow up on that, there's a question here. Who is responsible for the new FMLA payments under the new bill, the employer or the state?
The employer is responsible for the new payments, but they can get reimbursement through the tax credits that I mentioned.
Okay. And let's see. You may have covered this. Part-time or full-time employees are part of this act. That's a question. I know I made it more of a statement.
Yes, both part-time and full-time employees are covered. I'd say with full-time employees, it's easier to assess how much paid sick leave they're entitled to. So that first bucket that we talked about. For part-time employees in general, they're eligible for proportional benefits. And it can be difficult in some situations to identify how much a part-time employee is really entitled to, because what if they don't consistently work 25 hours a week? What if sometimes they work 30, sometimes they work 10, sometimes they work nothing? Obviously that can happen too. And the DOL in its FAQ responses has tackled that issue. And essentially they've taken a very, what I'd call a pretty reasonable approach to it, and essentially suggested that the employer look back a reasonable period of time, I think it's like 6 months, or the amount of time that the part-time employee has worked, and come up with a calculation that expresses on average how much that they work.
Thank you. With the COVID-19 situation occurring, many states, counties have become unavailable to run background checks. How can we hire employees without a background check run?
You want to take that first, Jeff, or would you like me to?
I would just remind everyone, Orange Tree is operating at full capacity. If you are a client of ours, be sure to reach out to clientsuccess@otes.com, OTES.com, and we'll definitely help you and provide any clarification that you may have or need. If you aren't working with someone who's available at this time, feel free to reach out to that same email address, and we'd be happy to understand how we can help you. Is there a more general response, Scott, that might be pertinent beyond what could be perceived as a self-serving response?
Yeah, I would say the more general response is that, yes, it is more difficult right now for full background checks to be completed. right? There are situations in which if a county criminal check is run in a particular jurisdiction, the court may not be available to provide information to the background screening company that's necessary to process that particular check. But what I would not say is that background checks can't be conducted at all. I would say in general, they are being conducted. They are largely being, significantly being completed. There are situations in which it is imperfect or not all of the same information that normally would be obtained is obtained. But I would say that background checks on the whole are moving forward. The other thing I would suggest is that for companies that have to rely essentially on partial background checks right now due to court closures, there's nothing to stop the employer from informing the employee, we're going to bring you in now based on the background check results we have to date. But understand that we are not able to complete our normal background check right now. And as soon as we are, we will complete the normal background check on you subject to your consent. And if we find something in the future, we are going to bring that to your attention, and that may affect your employment.
Thank you. What if an employee is unable to telework for their regular 40 hours per week? Are they eligible to get some of the time for the remainder of the hours?
Yeah, I think the answer is yes to that question, right? So once they're not able to telework, then there is a period of time that they're essentially out of work when they would normally be working. And if they're out of work for one of those qualifying reasons that we went through, then they're eligible for reimbursement in the way that we described.
We may have covered this one too already. Does both the PTO and the expanded FMLA Child Care Act or FML Child Care Act is it only applicable for employers with less than 500, or is it just the PTO portion?
Yeah, both provisions are applicable only to employers of less than 500 employees.
If the employee is under a shelter-in-place order, is that considered the employee's own coronavirus-related condition?
Well, keep in mind, the shelter-in-place order likely falls under the first prong that we talked about. There's a stay-at-home provision as one of the qualifying criteria. So yes, that would be subject to that would allow for the taking of paid sick leave benefits, and it would fall in the category that allows for full reimbursement subject to the caps that we talked about.
Okay. May have covered this. Can an employee use the new bank of sick time to cover the 10 days uncovered FMLA?
Yes.
Okay.
One thing I should add is that employers cannot require employees to use other leave or sick pay or vacation benefits that they are accorded more generally by the employer. So everything we talked about today related to the sick leave pay or the sick PTO pay or the expanded FMLA, that's separate and apart from any other leave or benefits that the employer provides.
For the 200 in expenses under FMLA, could childcare costs be a qualifying expense?
I'm not sure I'm following that question.
Let's see if there's a
the $200 relates to reimbursement for reimbursement that's given to the employee for missing out on their wages, right? Because they can't telework. If you're asking, they're able to work, but they have increased childcare expenses, are those reimbursable? I think that company can voluntarily choose to reimburse those. I don't think that they will be eligible for the tax credits based on what I've seen.
Okay, so a broad distinction is wages, not expenses.
Mm-hmm. Now, the one caveat I'd make to that, though, is that certain health insurance expenses, I do understand, are potentially reimbursable.
Okay, there's a comment here. Government entities are not restricted to the 500 or less. We are required to observe both.
Yes, I think government entities, so everything I've talked about today has been in the context of private employers. I think the answer is correct. I think government entities are subject. There are some different rules, as I recall, slightly different rules in the government context. I'm less familiar with those, but yes, the government is in play on this as well.
Thank you, and thank you, Kari, for that comment and point of clarification. Scott, we've been asked, could you repeat the response? Does the emergency FMLA impact regular FMLA benefits in the future, and/or is it a different FMLA bucket? We had dogs barking in the background. I share that not to make fun of the person or the people, but just because that is the times in which we live.
It very much is. This is, as I was saying to you, Jeff, this is the very first webinar I've given from my bedroom before. You know, I'm sitting here answering this question, I think the answer is yes. It will limit their ability to take other FMLA benefits in the future if they take these 12 weeks under the expanded FMLA now. I think there is a possibility that that interpretation that I have right now could change, but as I'm sitting here right now, I think yes, that's the case.
Okay. If an employee was temporarily laid off, furloughed prior to April 1st, are those employees considered on leave? Would they be covered under this legislation?
Yeah, it's a great question. And it really depends on the details, right? Because I've talked to all different employers about furloughs and whatnot. And the key comes down to, is the employee's employment terminated or not, right? And so when people use that phrase, sometimes they mean the employee is placed on inactive status, but they still consider the individual employed. Other times they mean no, the individual is no longer employed and there's no promise that they're going to be returned to their position at any time in the future. I think the answer is that distinction matters, right? So if the employee's employment has ended, they are not counted. If the employee is on inactive status but not actively working day to day, I would expect them to be counted, yes.
There was a comment about covering larger employees. I know this act, which is the nature and focus of our discussion, is 500 or less, because that is the applicable group. Is there something larger employees should be taken away from this?
Yeah, so good question. I would say the biggest takeaways for the larger employers right now don't relate to the sick leave or the expanded FMLA. It relates to the other issues that we talked about, from layoffs to reduced hours, et cetera. Is there still an option for employees to potentially claim FMLA benefits? What I'll call the normal FMLA benefits? I think the answer is, in some situations, yes, right? So if they have a serious medical condition and they otherwise qualify for FMLA, and that serious medical condition relates to COVID-19, there's no reason that the COVID-19 would serve as a disqualifying factor. But I would say the expansion of rights under the FMLA and the sick leave PTO portion, that does not apply to larger employers at this point.
Okay, thank you. Is there an age limit for kids under the FMLA provision? For example, if a high school senior is home from school, is that person covered?
That's a really good question. I have not seen any distinction based on age.
Okay. Thank you. Let me just see if I can peruse. I know there's, I apologize to those of you who are waiting, especially if you're waiting for an answer to your question. I think we have most of them. Just bear with me 1 second. We had, I think we touched on this, but it's just at the risk of even repeating it. Can we require employees to request this paid leave? Also, can we require them to provide proof of doctor order or daycare closure?
Yeah. In terms of requesting the paid sick leave, I think the answer is yes. You can leave it to them to request it. I have not seen anything to the contrary. In terms of proof that they qualify, I would tell you my best judgment as I'm sitting here right now is that yes, proof can be required, but that's another area that I consider to be fluid.
Okay. And I think this will be the last one. If the state has a stay-at-home order, but we are exempt, can the employee who elects to stay home collect unemployment?
Can they collect unemployment? So collecting unemployment is a different question, and it's going to be state specific. What I would say in that context is you have an employee that's voluntarily choosing to stay home because of whatever risk they perceive. I think it would be dependent on the state unemployment law as well as the state unemployment agency to figure out whether there is a basis to allow the employee to collect unemployment in that circumstance.
Okay. Scott, I think that does it. Thank you for staying. If you can see the slide at your remote location, you can see why we had the number of microphones on the chart. So thank you very much for adjusting our webinar, being pertinent to what people want to talk about. Thank you everyone for joining us. Again, there will be a follow-on email with a link to the webinar. You can listen to it again, share with colleagues, whatever you see fit. Handout for download, and if you have any questions, you can email me at jernste@otes.com or clientsuccess@otes.com. That concludes today's webinar. Thank you very much, and have a great day.
Good luck, everyone.
Thanks again, Scott.
Thank you.